Hello, my name is Brian Ka, and in this video, we're gonna go over question 4 from the February 2016 California bar exam. And just like the other 5 previous videos, we're gonna continue to do remedies and try to do as many as we can before moving on to wills and trusts. So in this fact pattern, as you know, I like to always read the call of the question. And in this question, it's a two-part call of the question. The first one, it says, what is the likelihood of success of Insurco's complaint and what defenses can Pop reasonably raise? Okay, so number one, likelihood insurers complaint. And number two is the likelihood of Pop's P's complaint. Right? We don't know anything about this case. Just from reading number one and two, we can have an idea of what to look for, kind of. Now, one paragraph above that says, Insurco filed a complaint against Pop for rescission of the policy. So the complaint here is rescission, right? For number two, it says likelihood of Pop's complaint. And what was his cross complaint? It was to reform the policy, otherwise known as reformation. Okay, so this is something about policy. It may be something about insurance, life insurance, car insurance. Let's see what the facts tell us. So here, Pop obtained a liability insurance policy from Insurco covering his daughter Sally and any other driver of either of his cars, a Turbo and a Voca. The policy limit was $100,000. Okay, so policy at 100,000, right? Covers two cars, Turbo and Voca. And who's covered? Sally or any others drivers. Okay, that's pretty straightforward. Sally or any other drivers. On the application for the policy, Pop stated that his cars were driven in hometown, a rural community, which resulted in a lower rate than if they were driven in a city. However, Sally kept and also drove the Boca in Industry City while attending college there. All right. So Pop stated that his cars were driven in a hometown. Policy was that driven in H, which he did that because that was a rural community, which typically results in a lower rate, and they tell us this. But Sally kept and also drove the Boca in Industry City while attending college there. It's driven in, he said that it was driven primarily in hometown, but Sally drove in industry city. Right? So driven in um, hometown, but Sally drove in industry city. And that kind of leads us to maybe think about uh, misrepresentation, right? Because, simply put, he lied on this um, application. And as you know, insurance companies don't like that. And they usually get back at you, if something happens by not paying you using, excuses. And majority of times they use the excuse of, hey, you didn't properly fill out the application, you lied, and we have a policy saying, if you filled out the application in error or you had intent to misrepresent, then we don't owe you anything. That's what usually happens in real life. And I think maybe the facts are going to lead us there. So here, let's make sure that we note that there may be a misrepresentation issue. Subsequently, Pop asked Insurco to increase his coverage to $500,000. The second thing is he wanted to increase the policy to 500,000. Insurco, they agreed if he paid a premium increase of 150, and he did so. Days later, if you pay 150, right? Days later, as he was leaving for Sally's graduation, Pop received an amended policy. He failed to notice that the coverage had been increased to 250, not $500,000. Okay, so he wanted this $500,000 policy. They agreed that if he paid 150 premium, that he would get it, but he ended up getting a policy for 250. The facts, uh, so far, it doesn't hint that Insurco was aware of this mistake. So it probably is going to, touch upon mistake, and most likely it's going to be mutual, right? Unless the next paragraph says something like, you know, Insurco was aware that they had made this mistake and they proceeded to just, you know, just ignore the fact that they made this mistake and move forward anyways. Unless we see something like that, this is probably going to be a mutual mistake issue. Unfortunately, while driving the turbo in Industry City, Pop caused a multi-vehicle collision. At first, Insurco stated it would pay claims, but only up to 250,000. But 6 months later, and we talked about this earlier, how it goes in real life, Insurco informed Pop that it would not pay any claim at all because of his statement on the application for the policy that both the Turbo and the Boca were located in hometown, right? So they're saying that you lied on the policy, so we don't owe you anything, right? And then we already talked about this, the call of the question, and again, Insurco filed a complaint against Pop for rescission, and Pop filed a cross complaint for reformation. So the organization should be fairly simple. The first question we're going to have to discuss rescission, and the second we're going to have to talk about reformation. The first thing that comes to my mind when you talk about rescission or reformation is that there's got to be a grounds for rescission, right? If you don't have grounds for rescission, then you can't get rescission. And what are grounds for rescission? Usually, it's misrepresentation. We discussed it here. Um, It could also be mutual mistake, and sometimes it could be unilateral mistake if it was done with intent to defraud the other party. But here, we didn't really see that. So it seems like to argue rescission, he would probably go into misrepresentation and mutual mistake, uh, or we're talking about in Sherco, uh, they're gonna try to argue these theories in order to argue rescission, right? So to rescind a contract, you have to know the elements for representation, misrepresentation, and that is usually statement of fact, statement of past or present fact. Usually we talk about center, in their mind they had intent to defraud, and there's gonna be reliance and material. The misrepresentation has to be material to the contract, and it's got to be the basic assumption, right? So the statement of past fact was that, you know, here Pop said, in or wrote down in the application that his cars were driven in hometown, a rural community, which resulted in a lower rate than if they were driven in a city. But Sally kept and also drove the Vulcan Industry City while attending college there. With Center, we can also argue that he had more than enough reasons to have intent to defraud, because unless he lied about who was driving the cars, the insurance rate would have been more expensive, right? So I guess Insurico has a good argument for arguing Center. This was obviously material to the contract, because usually for car insurance or even life insurance, um, answering questions to the best of your ability without lying is usually very material, and this fact was basic assumption in which both parties relied upon, right? And here comes reliance. So here, I guess you're gonna try to argue both sides. It'll be a little bit difficult to represent Pop here, because it seems like the facts are trying to lead us to, say that, most likely or probably that the court will side with uh, Insurco in this case, and unless there's defenses that apply here, Insurco will probably get rescission under the misrepresentation theory, right? Now, the second option that uh, Insurco has is to rescind this contract based on mutual mistake. And mutual mistake is when both parties were mistaken as to the basic assumption of the contract, right? And it was material to the contract, and they both justifiably relied on that mistake. Um, Obviously, here we mentioned something about mistake here, um, and this part where the mistake happened was when Pop was trying to raise his insurance limit to $500,000, and they had an agreement that as long as he pays 150,000, that he would get this $500,000 limit policy. But they're both mistaken as to the basic assumption, which was that they agreed for 500,000, but he ended up getting 250,000 policy, right? Now, they obviously relied on it because this car insurance was still valid when the accident happened. So I guess for mutual mistake, this is another theory that Pop can use in order to argue rescission. Again, we're talking about misrepresentation and mutual mistake because these are grounds for what establishes rescission. And that's why we're trying to get into it and argue. But in this case, um, although both parties were mistaken as to the figure, they wanted 500,000, but the 150 dollars an increase ended up being 250,000. You doesn't really seem like a good way to argue that there was a grounds for rescission. It seems to me that misrepresentation is just a stronger grounds for rescission. So I would argue that although he can try to say that they were mutually mistaken as to the basic assumption, and they thought that it was going to be $500,000, but instead they got 250. Although there was a mutual mistake here, the chances are to argue rescission for insurance company misrepresentation is probably the better argument. So I would write that and conclude that rescission granted under misrepresentation. The thing about remedies is like, yeah, you have to know how to argue rescission. Uh, you have to know some defenses, in which we're going to talk about here. The main two things that I always see are unclean hands plus latches. Unclean hands basically, um, Pop can argue that Insurco was at fault, and because you're at fault, you did something wrong. Your argument for rescission shouldn't stand, right? Latches is unreasonable delay which prejudices the defendant. I don't really see latches here. Unclean hands, the best that Pop can argue is that you made a mistake of this increase that we agreed upon, and it was supposed to be $500,000, but you gave me only $250,000 policy. But that probably won't fly as a defense under unclean hands unless there was like something that was obvious that Insurco did. Uh, Unless you have that, these defenses will probably fail. So, because these defenses will probably fail, the conclusion that we drew, that rescission will probably be granted under misrepresentation theory will, probably stand. And that's what I would argue under rescission. There isn't much uh, to argue. It's just that, as I wanted to talk about this earlier, that even though this is a remedies question, you have to kind of refresh yourself of how to argue misrepresentation. For me, it's been such a long time since I did torts, so I probably have to hone my skills in going through these elements. But unless you know the elements before misrepresentation, you can't argue rescission. Same thing as mutual mistake. Unless you know the elements, you're not going to be able to plug in the facts. And if you don't know the elements for a mutual mistake, you're not going to be able to, use the facts. And eventually, you're not going to be argued that this was a grounds for rescission. So, I guess again, for remedies, it's important to know the elements for contracts or torts, because the bar usually you know tests us under torts and contract. And unless you know the theories behind it cold, you're not going to be able to complete these essays, and it's going to be difficult. Now for reformation, it's the same thing. um, you're going to have grounds for reformation, and this is Pop's argument, right, by Pop. And he wants the court to reform the contract from $250,000 to $500,000. That's the argument he wants. And for reformation, also usually the grounds for reformation is a mutual mistake. And I would use the elements that we briefly went over. I'm sure I can do better on that after I review what exact elements were required in mutual mistake. But anyhow, I would use these facts, see supra, and argue that there was a mutual mistake. And under this, because they were mistaken as to the basic assumption that it was going to be 500,000, but they got 250. It was material, and both parties relied on it. Um, Under Pop's argument, to reform the contract to better suit the contract uh, to basically to show better the original intent of both parties, they're reforming the contract to show the intent of both parties. Then I think that reformation will be a probably good argument. But the problem here is that under unclean hands or latches, which are two defenses that you should always talk about when you do remedies. I guess you can talk about you know parole evidence, because if the bank could basically argue that if this was a complete integration, meaning it cannot be changed, to change the material meaning of the contract. I guess they can argue parole evidence, but the main thing here, I think, will be unclean hands, because as we've discussed, if if Insuro can successfully argue that Pop was at fault, and because he was at fault, he did something wrong, that Insuro should prevail on this defense, thereby making this reformation invalid. And I think they have a pretty good argument for that, because they can bring up this misrepresentation facts, saying that he misrepresented on this policy application, saying that, you know, he was driving these two cars as well as any other cars in H, but it was clear that Sally was driving the car in Industry City, and he probably had more than good enough reason to know about Sally driving the car in Industry City rather than in H, city of H. And the reason for that, as we've already talked about, it was to save money, right? So although Pop can probably try to argue reformation, ask the court to uh, reform the contract to better suit the original intent of each party, because this unclean hands defense would probably be stronger, I would conclude by saying that yes, reformation, but because of defense of unclean hands, it is unlikely that Pop will be able to reform the case. And it seems like this question was a little bit shorter than the other questions we've done already. And I think it's also a little bit easier. It's easier because they're telling you to talk about rescission. And, as long as you know the rules for rescission, there's only like so many ways that you can argue rescission. Um, you know, that wasn't too bad for number one, part one. Number two, you know, for reformation, it's the same thing. You gotta know the grounds for reformation. But if you don't know the rules behind what are grounds for reformation, and this in this case it was mutual mistake, and for rescission it was misrepresentation. If you don't know the rules for those torts, then this essay would have been difficult for you. So again, it's so important to um, briefly go over all the contractual um, roles. You have to know all the torts. They test you on everything. And I think for remedies, sometimes you just have to get into these torts, be able to argue it, say that, there was grounds for rescission or there wasn't grounds for rescission. And that is very important to successfully write these essays. And I would give this maybe like a 5. The one before this was like a 6.5. I would have been pressed for time just outlining that and trying to finish it. But here, I think for me, outlining this would probably take like 15 minutes or less. And I think the important thing here is to use the facts, because the facts are a little bit complicated, and to put my head around that, it probably required double reading, or maybe read it 3 times to just make sure what's really happening. Because if you don't know exactly what's happening behind the scenes, you can't really represent either the Insurco or Pop in this case. So with that, I hope that this was another helpful video for you. And I don't think that we have that many left for remedies. I can't guarantee that I'm going to cover everything and upload everything for remedies, but I'm going to try my best. And after we finish as many remedy essays that we can finish, we're going to get into wills and trusts, and we're going to work on those. So again, thanks for watching this video, and I'll talk to you next time.